Property rights in general have their origin in pre-constitutional manifestations throughout our society. Of course, the drafters of the Constitution were wise enough to include intellectual property within the document itself, thus enshrining it in our most important instruments and our most important implementation. It's a little strange, therefore, to be talking about property rights as administrative, but indeed that has been somewhat of a trend throughout our even constitutional jurisprudence. The property rights have become more and more administrative. Is that downgrading them? I don't know. Maybe that's part of what we need to talk about today. Clearly, with the new Patent Act, we're going to have a good many more administrative implementations of property rights and administrative checks on the way those property rights are administered. With that, let's get started with our wonderful panel. We're going to start with Ryan Triplette. Ryan is our star. She's a lobbyist and strategist with the boutique New Economy firm of the Franklin Square Group. She represented Intel in the past, worked extensively on the Senate Judiciary Committee. Ryan.
Well, thank you, and I don't think I ever thought I would be called a star by you, so really thank you for that. I guess my primary purpose for being on the panel is to give a little bit of history to the AIA. My background, as was mentioned, was for, I believe, about 4.5 or so years of what was about a decade debate over the AIA. I was on the Senate Judiciary Committee and specifically was working for then Chairman and Ranking Specter, Arlen Specter. So have a little bit of an in-depth view of what was the driving force, and specifically what was the driving force behind any revisions to both the inter-parties review process and post-grant review. Kind of first and foremost, what I think is very interesting about this panel is when I was on the committee, the question that we constantly were asked, and what we asked of ourselves in any revisions that we were looking at making to the law, it was never, are we undermining property rights? It was, what are we looking to do to define and refine the extent of property rights to ensure that a patent is properly valued to reflect its innovation? So in looking at what the purpose for these new administrative processes, I would say that's the context in which they were created. They came as a result of, I would say, primarily the FTC's 2002 and the 2003 National Academy of Sciences reports on the necessary changes or the suggested changes that should be made to the patent law, looking at a number of flaws that there were in the patent system. What's interesting is, in looking at this and kind of preparing some notes for today, I flipped back through these reports, which after all the years on the Judiciary Committee, I really never thought I would have to open up again. Specifically with the FTC report, I found that there were a lot of consistent messages and that still exist today, and what could be considered items of concern within the application of the patent law, even post AIA. Primarily, the danger of ambiguous patents to driving innovation, and the potential cost on innovation that these patents, that you do not know exactly what they encompass. So, that was truly the context in which this was driven. It's something that all along, it was both of these processes, administrative processes with IPR and the new post-grant review process, it was intended to address the problem of increasing litigation costs. It wasn't intended to undermine property rights. It was intended to help draw a fence at a reduced cost. It was intended to encourage people to actually increase the value of patent rights so that when it really comes out of the PTO and you come out of these processes, you have, I can still remember a term that somebody used, I think back at the point, was like a gold star check on patents that were coming out of the PTO that had gone through these different processes. So that was really the driver behind it. I do want to kind of pivot a little bit and think that what has been very interesting is that although that was many of the purpose, that was a driving purpose behind these new administrative processes, it's a purpose that I think didn't actually get accomplished. The limitations that were drawn around these new, around the new IPR and PGR, it actually, it was intended to be used more and be something that people would actually turn to the PTO rather than the courts. We've seen, rather than that happening, we've seen increasing litigation costs. So I think that throughout the process, there was a degree of frustration. And I think it's why you see many industries and many, whether both large and small, say that there is a need to still look at the patent system and whether further refinements, whether they be regulatory or revised legislation or have the courts address them themselves, that there still needs to be increased checks in what's happening over at the PTO. So I know there's been a request that I keep my comments short, and more than anything, I want to hear what questions there are. So I'm going to kind of limit there and give my historical perspective and really look forward to hearing what the others have to say.
Thank you, Ryan. We'll next hear from Professor Richard Epstein from Chicago. I don't think I need to say anything more. And NYU.
That's right, teacher.
Okay, go ahead.
Yes. 40-odd years at Chicago. I'm now a regular member of the NYU faculty in the senior unit.
Sorry, I missed the
That's
change.
okay. I mean, when you look at the Chicago website, you get one result. You look at the NYU website, you get another. There are branding rights associated with these titles, but that's the soft IP panel, not the hard IP panel that we're involved with here. And let me sort of state at the beginning that I've actually was quite closely involved with many features of the enactment process with respect to the AIA. I did so as a representative of a company known as Data Treasury, which had a patent which allowed it to image various kinds of devices, most notably credit card receipts and checks, which have been subject to countless challenges on all sorts of grounds in the courts and to countless efforts, at least two major ones, in the Congress to sort of invalidate its patents by changing the substantive rules with respect to their operation. Before we got to the AIA, there were efforts, of course, in the Congress to change the substantive rules insofar as they related to injunctions and damages to reflect what Ryan called the effort, which I regard as hopeless and misguided, to make sure that when you give patent protection, it reflects the incremental value that the patent adds to society instead of trying to create some kind of a property right. What I want to do in the short time that's allowed to me is to address the question of what consequences, what difference, if any, is made when you start to think of something as a property right, even in something like intellectual property, relative to treating it as an administrative convenience. This is not the only area in which this thing arises. If you go back to the history of the spectrum, you'll discover that exactly the same battle took place in connection with it. There were efforts to create ground-up patent system or frequency rights in the 1920s, which founded for a variety of reasons. We then put into place an administrative system of allocation in which what you did is you got down on bended knee, begged the government to give you something of value so that you could sell it off to the highest bidder once it turned out to come your way, and that whole system, in effect, created an inferior system of rights which allowed for higher government regulation on the one hand and created rigidities in use and alienation on the other. That, I fear, is what is likely to happen in connection with the patent system. And to put the point in its version, if you go back to the 19th century, the essential view that one took about the patent system was as follows. Congress had the power to decide the way in which it would create patents, the duration it would give them, and essentially the boundaries. But once a particular patent was created within the system, this patent was regarded as a property right the same as any other property right, and was therefore subject to the same protections, A, with respect to procedure and res judicata, and B, with respect to confiscation, with respect to the compensation that you received under the Just Compensation Clause. And essentially what happens under this particular system, when you treat the thing as though it's a strong system of property rights, what you do is you manage to infuse several very strong features associated with its operation. One of them is that, of course, you can now define exactly what is in this thing. You can't do it by metes and bounds, but you can certainly develop a series of processes which would allow you to determine the outer perimeter of rights in the claim specification so that the infringement action looks as though it's a mirror image of the good old trespass action with respect to land. You don't get 100% efficiency, but the point is the more you try to make it look like the land rights, the more likely it is that you will succeed. And the moment you start announcing that ambiguity is the rule of the road, what will happen is you will actually increase the amount of ambiguity you have. People will start to try to finesse the system in one way or another. The other two features that you want with respect to a strong system of property rights is one is you always want to have a system of injunctive relief. Because if you do not have that particular system, what you do is you encourage all sorts of strategic behavior by various kinds of individuals who decide in deep and very strong convictions that the optimal strategy is to essentially invade the patent and then let them come after you and sue for damages when you'll try to lowball the industry in question by making sure that all the damages that they're requiring are going to be to some extent speculative. And if people know that when they create new inventions, they're going to have to face multiple lawsuits by multiple parties, it's going to be a real deterrent for their willingness to do so. And what the injunction does is it essentially stops that kind of behavior. And ironically, this probably increases competition in the market because if the first guy is able to get the injunction, somebody who wants to get a patent which covers the same part of the market but uses different technologies and devices is more likely to enter. And one of the things that I think is quite clear, a new patent which gives you an alternative is a much better way to disseminate information and to create variety in the marketplace than allowing people essentially to force compulsory licenses by these kinds of various sorts of manipulative behavior. And it's for that reason, I think, that the decision that you had in the eBay case was such a long-term disaster, because what it did is it made it appear as though these things were highly discretionary, and it also called into question an issue which has still not been resolved, which is whether non-practicing entities, the NPEs, are in a position where they can bring injunctions when they don't, in fact, manufacture the goods in question. And in fact, you want to give them that protection because there's nothing whatsoever about the economics of markets which says that you should only be allowed to enter one market, that is the resale market or the licensing market, conditional upon entering another market, the manufacturing market. If in fact you have specialized skills, the ideal response in all of these cases is to allow people to go unencumbered into whatever niche of the market is the one which is most congenial to them. The other recent decision, which I regard as completely dangerous in this regard, was the decision in Quanta and LG, where in effect what they did is they announced that there's certain kinds of inherent limitations with respect to the patent system, which meant that you could only have your restrictions bind on the first party. And the correct result in this particular situation is that you should be able to create either sales or licenses at your free will, and in effect, so long as you give notice to the rest of the world, make it very clear that these things bind not only the original recipient, but those people who take by way of transferees on the grounds that they cannot be bona fide purchasers if they in fact have notice of the situation in question. Anybody who wants to put strong restrictions on resale by the initial patentee is going to have to pay a price, and so generally speaking, these things will only be imposed for cause, and there are going to be many cases where restrictions of this sort will make some sense. For example, in the case called Augusto, if you start giving demonstration tapes to your various DJs or other publicists in the movie business and say you cannot resell these things, you're trying to get publicity, and you call it a license and you want to return it. If in fact these things can be resold, then in effect the only way you could get publicity is to essentially depreciate the value that you have in the consumer market to which you're selling, and so in the end you will probably have a weaker system than if the strong property rights will start to be observed. And so what happens if you start to look to this particular system, one of the common complaints that is made about it is that it becomes extremely difficult to litigate in this system. You spend a lot of money on these disputes. The problem is the increase in the litigation in many cases is attributable to the weak rules that you have with respect to property rights. Now, the same point applies with respect to the issues that are so controversial under the AIA, mainly those things that have to do with the PTO and the relitigation of disputes that have already taken place in court. And the issue then is, how should we want to think about these things? If you start with the property rights model, as I do, and don't start thinking about this as an administrative model, this is the kind of reaction that you have. First of all, when you have an adjudication which goes to final judgment, as between a patentee who brings an infringement action and a potential infringement, that judgment is final and is binding is between the parties in all forms, present and future. So that one of the most dubious features, I think, of the PTO system is that the ability to relitigate these things under a lowest standard inside the PTO before a series of panels which could be specially assembled for the purpose in each individual case, which gives rise, in my view, to very serious due process concerns as to whether or not these panels can be rigged in some way, shape, or form. What you've done, in effect, is you have allowed for a kind of confiscation that comes by allowing these particular challenges to take place. And Judge Newman, I think, on the Federal Circuit has been the most vocal, if I'm not mistaken, in talking about these kinds of issues. And I guess the most recent case where she lost was the one involving Baxter International. Adam will know this better than I, but I think I have the name right.
Got it?
You would know it better.
You
Jim.
got it.
So, I mean, you have this constant sort of tension. You also have, and this goes consistent with the sort of attitudes that we take today towards the administrative state. Prior to the administrative state, it was thought that not only was federalism regarded as an essential bulwark for liberty, but also the separation of powers was regarded more or less as though it was an essential bulwark of liberty. And the theory behind that is if you can only go to the judiciary in order to get a final judgment, what it would do is eliminate the amount of game playing it take and the amount of strategic behavior as people desperately sought the right form for themselves out of the medley of choices that was to be given to them. And if you therefore look at this particular situation, the dominant case outside the patent area is a case called Plout. And it takes the fairly strong position that a final judgment is a final judgment and you cannot challenge it anywhere else. And the rules by which it can be undermined are to be determined by the jurisdiction which issued the judgment, not by those to which it is taken, again to stop the strategic behavior, because there's only one place that issued it and there are 1,000 different places to which you could go in order to challenge it. And once again, it seems quite clear that in this particular area, we see that this principle is also under assault by the extent that you could now relitigate these issues in another tribunal located either in the executive or the congressional branch with the administrative government. State, of course, we have no idea where the PTO is located in some fairly deep sense of that word. And that, too, creates this constant pressure to undermine the validity of a patent by allowing a second crack at the apple. So what's the bottom line with respect to the situation when you put all of these pieces together? It's that all of the objectives that the defenders of the modern administrative state hope to achieve through their expertise, that is trying to get more predictable patents, trying to get gold letter patents coming out of the system and so forth, trying to make sure that you kill weak patents off, every one of these objectives will be frustrated by the American Invents Act. Now, how do I find this happening? Well, I'll just close with the following remark. If you go back to the history of the 1952 Patent Act, which I regard as a quite splendid legislative achievement, essentially Giles Rich and his friends got together and said, what do we want to do by way of patent reform to get rid of some of the rather misguided decisions, particularly by Justice Douglas in the Supreme Court, which seemed to weaken patent protection? And what they did is they came up with a short, coherent statute, and notwithstanding the fact that you can find nits and flaws with it here, there, and the other place, basically this thing was a towering achievement. When you come to the AIA, what happens is everybody from the banana farm comes down into Washington and desperately says, do it my way, do it this way, do it that way. Instead of getting a committee that actually knows something about the subject just doing it, you get several $100 million in lobbying expenses and God knows what else being brought into the situation. You get a statute which is 5 to 10 times as long, and the only thing that you can say, a universal truth with respect to constitutions and to legislation, is the longer the document, the worse the document. They're kind of inversely related, and this thing is vastly longer than the one that they had. It messes up not only this issue, it gets rid of some real problems in research patents, rehearings in other areas, business method patents, and so forth. And the basic rule with respect to legislative reform, which essentially is displaced when you deal with the modern administrative state, is essentially until you can show a serious defect in the day-to-day operation of a system, you don't fitz around with it in an effort to try and quote-unquote improve it. And so essentially what happens is, under the mantle of good government, what we do is we get large doses of bad government. Because every time you start to praise the virtues of administrative discretion, you necessarily conceal the correlative risk of administrative abuse. And in this particular case, as far as I can tell, by the time the dust settled, we will now have two patent systems side by side for many years, as the old one continues in effect with respect to patents before 2011. We lose some degree of clarity, and we open up this field for greater levels of political intrigue. In Washington, these days, this sort of counts as progress, but from where I come from, with a more sort of 1787 Lockean kind of view of the world, this is progress running in reverse. This is government running wild. Thank you.
Hooray for Locke. I'm very tempted to cancel the rest of the panel and spend another hour commenting on everything you've heard, and it was, to my ears, inspired. But I'm afraid we have to hear first from George Contreras
Thrilled to hear from you.
and Adam Mossoff. George teaches at American.
Thanks. Yeah, you go up there, okay. There we go. I've been directed to the big podium. All right, well, thank you very much. I will try to keep it short, because I also would like to follow up on Professor Epstein's comments. But I'd like to take a slightly different perspective this afternoon. The perspective that I come from is one of looking at the patents that we have out there. I will deftly avoid the debate about property-like characteristics of patents for the moment. But I think that anyone who's looking at patents that have been issued over the last 20 years will agree that at least there are some that are rather broad and probably reflect more the ingenuity of the patent lawyer who drafted them than the inventor who is listed on the patent. And this is a function of many things, including the way that our patent system structures claims, right? The protective element of a patent are structured in words, claims that come at the end, and they can cover all sorts of things that aren't actually, well, I wouldn't say invented, but they aren't actually implemented in a technical solution that the inventor has. They are, in many cases, logical extensions of that, or clever ways of expanding on what an invention is. And there's been a significant amount of criticism from academics and others as to the state of claiming the breadth of patent claims in the US, particularly as they relate to technologies such as software and business methods. Mark Lemley at Stanford, in particular, has pointed out that the problem stems from what we call functional claiming, claiming functions of things as opposed to the way that they work and the actual inventions that the inventors may have come up with. And so this creates uncertainty. Professor Epstein talked about the uncertainty that can arise when patent holders don't know the scope of their rights. Well, there's another side to that uncertainty, which is the uncertainty that others in the market have when patent rights are unclear in this way. And there has been an awful lot of litigation. As we know, litigation is nothing new in this country, but simply looking at the types of suits that are being brought and the types of claims and the patents that are being litigated in many cases, I personally and many wonder whether this is productive and efficient for the market as a whole. So that's just a sort of overall framing perspective that I have. So we're here today to talk about one way that Congress has tried to address this and other issues with the patent system. And again, it's what Professor Lemley has called the regulatory turn in patent law, this administrative character that is becoming more prevalent in the patent system. And so we've already heard a bit about the new procedures that the AIA has created in giving greater access to the PTO in post-grant review proceedings of patents that have already been issued. And coupled with that is something that's happening in the judiciary, right? And we've also heard allusions to that. The greater deference that the courts are giving potentially to PTO decisions. And the Baxter case is one very good example of that. Melissa Wasserman, who is a professor at Illinois, has just written an interesting piece talking about the general extension of Chevron-like deference by the courts to determinations of the Patent and Trademark Office, which it typically has not enjoyed before. The PTO was not viewed as an agency to which Chevron deference was applicable because it did not have rulemaking and adjudicatory power. It now does, under the AIA, at least in theory, have adjudicatory power that may raise it to the level of an agency that warrants Chevron deference, and that's a very high degree of deference to the agency's rulings. Some would say that this new power, this new administrative power, is tempered somewhat by decisions like Hyatt and Kapos, which is a Supreme Court case this year, but I am skeptical of that. I don't know that Hyatt can be read too broadly. It's limited to the very unusual provisions of Section 145 of the Patent Act and the introduction of new evidence that a patentee has when he goes to court after his Patent and Trademark Office proceedings. I think it's a fairly limited exception if it is one at all. So we have these administrative features now added to the patent system. Is this the answer? Right, is this going to help at least with the problem that I see, which is the breadth and number of overly broad patents in the market? And my answer is maybe a regulatory turn might not be such a bad thing. I don't share Professor Epstein's inherent skepticism of a greater role for the administrative agencies in this regard, but what I am skeptical about is whether the AIA actually accomplishes or is likely to accomplish the goal, and whether the Patent and Trademark Office, as it is currently constituted, is the agency to do that. So what about the AIA? Well, as Brian indicated, as with every legislative process, except perhaps the 1952 Patent Act, it is a piece of compromise, right? The legislation involved many compromises, things being put in and dropped out until the very end. The review, the post-grant review procedures are limited, to say the least, right? I mean, at their most strong within the first 9 months after a patent is issued. After that, they become much more limited in scope. The scope of what you can challenge after that 9-month period becomes quite a bit more limited. For business methods patents, there are some additional ways to challenge them, but there were also proposals on the table to severely limit the existence of business method patents altogether under Section 101. That didn't happen, and so again, we have kind of a compromise with some elevated challengeability for business method patents. So the Act itself didn't go nearly as far as it potentially could have. And then we look at the agency that is in place to adjudicate these new post-grant challenges to patents that have been issued. And it's the Patent and Trademark Office, which makes some logical sense, right? They know a lot about patents, obviously. But the Patent and Trademark Office is different than other regulatory agencies in this country. It is not like the FDA or the Environmental Protection Agency. It is different because, at least in much of its public persona and the commentary by both Congress and others, is that the PTO is in the business of issuing patents. They are a patent issuing factory. Statistics about the PTO are almost always given in terms of how many patents are being issued per year and what the backlog is, as though patents were widgets, as though the issuance of yet another patent into the economy were necessarily going to be a good thing. And I'm not making this up. The commentary around the passage of the AIA was stridently in favor of reforming the patent system to enable the greater issuance of patents. The PTO, unlike the FDA or EPA or other agencies, is actually a profit center for the government. They make $1.4 billion, or in 2010, made $1.4 billion in fee revenue, which is significant. That is earned from issued patents, not rejected applications, or at least to a much smaller degree from rejected applications. The political discourse around the AIA all pointed toward increasing the rates of issuance. There were even some, what I think have now been agreed to be somewhat flawed analyses that equated patent issuance directly to job creation. And you can Google this and find statements by prominent people associated with the legislature that every patent issued would result in 3 to 10 new jobs in the United States. 2.8, okay. So there's the math is tricky. It's rather, but in any case, jobs as a result of patents. This ignores the fact that a large number, if not the majority of patents in the United States these days are granted to foreign companies. Nevertheless, jobs are linked to patents. The other thing to think about with the PTO and assuming this administrative role is that the PTO compensation procedures for its patent examiners are linked to their output. And a number of academics have written about this, starting with Josh Lerner and Adam Jaffe from Harvard Business School, who link examiner compensation, which you get a bonus when you grant an allowance, link compensation of examiners to increase in patents and the increase in patents that are potentially of poor quality. Shane Tu at West Virginia has a much more recent paper in which he analyzed more recent data and at least gave a somewhat more nuanced approach and thought that the compensation structure for examiners at least created churn because they're compensated now not just for allowances but also for rejections and so forth. So the optimal strategy for a profit maximizing examiner is to reject a few times and then allow all within as short a period of time as possible to maximize your paycheck. Right? So our 7,000 patent examiners are given incentives as they would be were they working in a widget factory to produce an output. Melissa Wasserman at Illinois recently studied the allocation of resources and allowance rates within the PTO based on the profitability of different technology areas, the classes, right? In some areas, you have far higher renewal rates, right? The PTO collects revenue at various points during a patent's 20-year life. Some areas are likely to be renewed at a much higher rate than others, and coincidentally enough, allowance rates in the areas in which fee generation is the highest turned out to be the greatest. So this isn't to say that there's anything going on that's amiss at the Patent and Trademark Office. Obviously, you want to incentivize examiners to be productive and work hard and so forth. However, it does strike one that this agency may not be the best agency to adjudicate the validity of patents in a role that is going to actually diminish the role of the courts in those very determinations. The agency is to a large degree interested in a way that the FDA and the EPA and other agencies given Chevron deference are not. So again, I don't have an objection to the regulatory turn per se in the United States patent law, but I do have some concerns with the way that it is being implemented. So, thank you.
Thank you. Our final remarks will come from Adam Mossoff, who is at George Mason, fine professor there.
Thank you. I'll continue the tradition of standing. I will also note that I first learned patent law from Richard Epstein, and he will forever be a Chicago professor in my mind. You can leave, but you can never truly leave. I'm also very happy to be here reading from notes on my infringing tablet, my Samsung. But wait, how can this be? It's infringing, yet I have it. So The American Invents Act has created some of the most extensive changes to the patent system since the 1836 Patent Act. It's widely recognized both by its supporters and by its detractors. And many of these changes, as have been identified by the other panelists, are administrative changes, grants of power to the PTO to review patents post-issuance, special procedures for reviewing different types of patents, carve-out exceptions for different types of patents from infringement actions and other types of issues. Now, much of my professional life has actually been spent studying the history of the patent system. And you might be wondering why I'm someone who is a specialist in patent history is speaking today about something that was enacted just last year. Well, last year is history. But more importantly, I mean, I've used actually, became interested in history and used a lot of it because I found it to be a very helpful reference for assessing claims that you've heard tonight already, or today already from our other panelists about whether there's increased uncertainty, whether there are in fact broader patents and other types of issues. And actually, what I've discovered in my research, my historical research of all the primary sources, judicial opinions, treatises, legislative histories, is that the early American approach to securing patents was very much part of the American exceptionalism that animated the early republic and played very much a role in the political and institutional issues that drove the American Revolution and, of course, the Constitutional Convention of 1787. And so just as the U.S. political system, in fact, has its roots in the English political system, the U.S. patent system does as well. But very importantly, those young, brash Americans broke from their forefathers, and contrary to English practice, early American legislatures, courts, and commentators widely embraced patents as property rights. They defined them as fundamental civil rights securing property rights, what were referred to by the legal term of our privileges, as that term is used in Article 4 of the Constitution, privileges and immunities, and in the 14th Amendment, privileges or immunities. And thus, one finds throughout early American patent cases, courts referring to patents as, quote, title deeds, unquote. They are using common law property concepts in defining how patent owners own patents. So multiple owners of a patent are referred to as tenants in common. You find wide use of property rhetoric. So starting in the 18-teens, minor justices like Justice Story, Chief Justice Marshall, you may have heard of these people, referring to infringers of patents as pirates and as infringers of patents as committing a fraud on the patent system. And as Richard Epstein identified so rightly, patents, unlike in England, were extended constitutional protections under both the due process and the takings clauses, which was very explicit insofar as it was contrary to the settled practice at the time that franchise monopoly grants, so special monopoly privileges that were accorded to people through legislative enactments, were denied such protections, as exemplified in the very famous Charles River Bridge decision in 1837. Now, ultimately, as part of securing patents as property rights, the young Americans decided that they would go a step further and they would create similar procedures for securing patents as property rights. And so they ultimately created the Patent Office in 1802 and dictated that this office would operate under the rule of law. So this is very contrary to early English practice with respect to recording of patents, and you had very fixed procedures and ministerial officers at the Patent Office in recording titles and new inventions. Now, the reason why I'm reviewing this is not just because it's kind of fun and interesting, of course it is, at least intrinsically to me as an historian, but that actually this conceptual and normative framework defined very much how early American courts first created and then enforced the many substantive and procedural doctrines that now comprise American patent law, or at least did up until the AIA was enacted last year. Now, interestingly, something that I found in my research was that there was actually substantive and procedural administrative actions by the Patent Office in the early 19th century, and that these were somewhat fairly common and that they were litigated as well. One prominent example was that the reissue right, so the right of a patent owner who has a minor defect in a patent, so a misspelled word or a misdefined term or grammatical mistake, could surrender their patent back at the Patent Office and receive a reissued corrected patent so that their patent was no longer procedurally defective and they could enforce it as needed. Well, this reissue right was actually created ministerially by the Patent Commissioner in the 18-teens. Now, there was no authorization in the 1793 Patent Act at that time, which was the governing patent statute, for the Patent Commissioner to do this. And no big surprise, when an owner of a reissued patent ultimately sued someone for infringement, the defendant asserted as one of his many affirmative defenses that your reissued patent is invalid because the Patent Office did not have the legitimate authority to actually provide you that reissued patent. It goes all the way up to the U.S. Supreme Court in a very famous case in 1832, Grant v. Raymond, with Chief Justice Marshall writing for a unanimous court. They not only upheld the patent and found that the defendant had in fact infringed it, but they affirmed the patent commissioner's unauthorized actions at the Patent Office in creating the reissue right. Chief Justice Marshall wrote that this was done within the, quote, spirit, unquote, of the patent statutes as enacted pursuant to the Article 1, Section 8, Clause 8, the Patent and Copyright Clause, which promised both the benefit to the public and the, quote, reward to the inventor, unquote. Also, another interesting example of a substantive and procedural action at the Patent Office that was not authorized per se under the statutes occurred in the early 1850s during what was then known as the sewing machine war, which has very many interesting parallels to today's smartphone war, which I've written on. At this time, Elias Howe, the owner of the patent in the lock stitch, who was a non-practicing entity, was suing all the manufacturers, including Isaac Singer. And Isaac Singer was very interested in validating Elias Howe's patent, and he was searching for much prior art. He eventually found a willing participant in his attempt to invalidate Elias Howe's patent, a man named Walter Hunt. Walter Hunt is a very prolific and famous early American inventor. You all know of him, or at least have benefited from his work. He invented the safety pin. Well, Walter Hunt was willing to receive substantial funding and support from Isaac Singer in recreating an alleged sewing machine that he had invented allegedly in 1834 in his attic and then never taken action upon and left it there to rust, and thus filed for a patent on this invention in 1853, claiming that he predated Elias Howe's invention of the lock stitch by 10 years. And so what then occurred at the Patent Office is what we now refer to as an interference action, or a priority battle determining which was the first inventor of the lock stitch, as either used in Walter Hunt's alleged invention and or Elias Howe's. And ultimately, the Patent Commissioner Mason decided at the time that yes, Walter Hunt may have in fact invented a sewing machine that used a lock stitch in 1834, but that he committed laches, or in patent terminology, he abandoned his invention and therefore lost his patent ability to seek a patent. And in fact, it was Elias Howe who had therefore obtained a valid patent on this invention and brought it to the public. Now, Hunt didn't roll over on this. He had spent, or I should say Singer had spent, thousands of dollars. This interference action at the Trademark Office began in the fall of 1853, and it wasn't concluded until the spring of 1854. It was reported to involve hundreds of pages of documents and hundreds of hours of testimony by various experts. And so Hunt appealed to the Circuit Court in D.C., and one of his claims was an early administrative law type argument that the Commissioner Mason at the Patent Office lacked the statutory authority under the then existing 1836 Patent Act to rule that someone lost an interference action on the grounds of abandonment. He argued that you can only lose it on substantive grounds, lack of novelty or lack of usefulness or the other patentability requirements. The Circuit Court in D.C. soundly rejected Hunt's appeal and his arguments and affirmed the ability of the commissioner at that time to actually rule on the grounds that he did in the interference actions. So what you have in both of these instances in very early years of the American Republic is the Patent Office is being given extensive administrative latitude given the function of the patent system in securing property rights in new inventions. Now, why care about this? Why should we care about this? Well, I think there are two very important reasons that we should care about this history. The first has to do, in fact, with the American Invents Act itself, which, as I indicated in my opening remarks, creates the most significant administrative apparatus ever created in the patent system. And as I indicated, the American Invents Act is, in fact, often compared to the significance of the Patent Act in 1836, which is in fact the first legislative patent act that creates much of what we now know as the modern patent system. And in fact, it's in the 1836 Patent Act, by the way, that Congress codifies the reissue right that was affirmed by by Chief Justice Marshall in his decision 4 years earlier in Grant v. Raymond. And so we will often see, and you will continue, we often hear, and you will continue to hear historical comparisons about what the American Invents Act has achieved or will be achieving in the patent system and what occurred in these earlier years. Just to give you one small example of some of the many historical comparisons that are already being made, Bob Armitage, former general counsel of Eli Lilly at an IP conference last December in 2011, stated on a panel on which I was with him on that the American Invents Act is, quote, more faithful to the Constitution than the original 1790 Patent Act, unquote. Now, setting aside such blundering claims that the 112th Congress in 2011 knows more about the Constitution than the first Congress in 1790, which actually contained some of the framers who sat in on the 1780, who participated in the 1787 convention. And recall also that the 112th Congress contained such notable public officials as the representative from San Francisco when asked, what is the clause in the Constitution that authorized the Obamacare, to which she responded, are you serious? Setting aside such statements that these people know more about the Constitution than they did in 1790, there is in fact truth in the claim that the Patent Office, which was created in 1802, represented one of the very first federal administrative agencies, and in accord with this was granted seemingly a similar deference that you see granted to administrative agencies today. But one should be careful about that observation, which leads to our second reason why the history that I covered is important. And that is because the administrative state that we now have in the 21st century is a very different animal than the administrative agencies that existed in the early republic. It was inconceivable to them in 1802 that in addition to the Patent Office, there would be an FDA and an FTC and an SEC and an FCC and an SEC and the whole alphabet soup list of regulatory agencies we have now. So we can, of course, learn from these early cases and from early disputes like the sewing machine war. But the most important lesson to learn is that the rules governing an administrative agency and its powers are very much defined by the institutional and political context in which that agency is embedded. Right? So the deference accorded to the Patent Office, for instance, in the 1832 decision in Grant v. Raymond and in the 1854 appeal to the Circuit Court of D.C. following Hunt's loss at the Patent Office and his interference action, very much occurred in a context in which patents were defined very much as fundamental property rights that were secured to first inventors. And that was the function in which the courts were reviewing the Patent Office actions, and that was the reason why they were upholding these decisions and granting this deference. But given the nature of the modern regulatory state, in which patents and other types of classic legal rights are no longer accorded such significant protection, per the famous footnote 4 in Caroline Products and our shift to rational basis review, and the shift in the American Invents Act itself in reframing patents more as regulatory entitlements and less as property rights, this means that administrative deference has significantly different normative and doctrinal import today than it did in the American patent system that existed from 1790 until 2011. So, thank you.
Well, at this point, let me invite the panelists to respond, if they wish, to anything that their fellow participants have said. What's that? Okay, Ryan, do you have anything you wish to comment on?
Well, I always have things I can comment on. I don't know, I think that obviously it was a great series of speakers. I don't take umbrage with Professor Epstein and his, I guess, painting. I didn't think we did that bad of a job back then. No, I think that it's something that needs to be looked at is what continues to happen and what the purpose of all of this is. I think that in looking at what these, I would say, administrative patents are, you have both a situation that at the time of drafting the AIA, there was looking at a series of very ambiguous patents that have been issued by the PTO. We're looking at a situation both then and what you're looking at what the implications are now. So no matter when you legislate, there's going to always be a series of systems that are going to be out there, and it's how it's going to actually be applied. And I actually agree that I think that right now there's more possibility for abuse of the current system than there existed before, and I think that is reflected in whether it's, again, the rising litigation costs. I think that I'm actually concerned that rather than using the PTO, people are turning to other, I say, quasi-judicial bodies such as the ITC.
Ryan, at one point you said that the patent system has become a danger to innovation. This is actually based on the scholarship of The Tragedy of the Anti-Commons, a article first written by Becky Eisenberg in the early 80s. She has studied it since. Are you aware of any empirical study that validates the idea that the patent system, or any series of patents, have stifled rather than encouraged innovation? It's a trick question. There is none.
Well, no, I don't know that that's absolutely right. I mean, there's certainly, if you just look at the litigation that's going on around Myriad Genetics and its patents on genetic diagnostics, I think you have reports and amicus briefs from many scientific organizations that say that because of the monopoly position that Myriad has in the BRCA1 and 2 gene testing market, that technology has not advanced in the way that other genetic tests have, and it's an inferior technology, yet others are not able to improve on it. Right? I mean, so that's one area.
I also one thing I said was
Let's hear from Richard here.
Look, I mean, the original claim was, well, first of all, the first series of innovations took place. Oh, isn't the mic on?
Here, use this.
The first series of innovations that took place were mainly the decisions in the early 1980s, starting with Chakrabarty, in which the scope of patentable subject matter were expanded, and the empirics on that are unmistakable about the huge level of growth and innovation that took place more or less across the board. It was much more important than, for example, the creation of a separate federal circuit court to deal with that issue, because this one impacted every case, and whereas whatever Judge Rader does and so forth, affects only a tiny fraction of cases. I think the article you're referring to is the Heller article of 1998, and then the Heller-Eisenberg article in Nature. And there were empirical studies done afterwards by Ariosho and a bunch of other people. They found absolutely no negative effect. And the reason they found no negative effect is that it turns out in many cases the appropriate way in which to handle these things, for example, with the research exemption, is you got a guy who wants to violate or infringe your patent in order to develop a series of complementary technologies that will expand your market. What you do is you say under your breath, thank you, and you don't bother to interfere because they're not going to be a direct competitor to you. And in fact, the only case on the research exemption that ever came up was the Maddie case, and that only came up because there was a scientist going from Stanford, I think it was, to Duke, who was trying to take his group with him, and so it was completely atypical. And so what happens, you get the AIA introducing a big old research exemption stuff, which like all of these things gets things wrong in the sense that in order to make life sweet for one person in the distribution change, you make it more difficult for somebody else in the change, and trying to find out the net negative or positive effect out of that enterprise is essentially hopeless. So that's a case of fixing something that really did not need to be fixed at a great deal of confusion and uncertainty. In terms of the other stuff, what happens is if you actually then try to figure out what's going on here, we do have a systematic increase in the number of patents that are issued. And in effect, at the same time, we have, even in something like the software industry, a real acceleration in growth of what is happening. And what's wrong with the critics of this stuff is they assume that everybody who owns these patents is simply clueless on how to develop them. And so what happens is we developed in the early 1990s a fairly sophisticated and good set of antitrust rules on the way in which you put patents which are complementary into a bucket, but not those which are substitutes for one another, which allows and facilitates cross-licensing amongst members to the patent train, and also allows you to license out as a mass to third parties. So all of these things are sort of, I think, understated in this particular stuff, and instead what you do is you get kind of freaky cases, the double-click patent and so forth. That patent claim has caused much more harm in the number of times it's been repeated as being sort of representative of the whole then good that it has turned out to be done. And, my own view about this stuff is I am willing to concede any kind of mistakes that takes place under an obvious test in an even case. I'm even willing to bet that Judge Rader hasn't gotten it right 100% of the time. I don't think anybody can. But that's not the question. The question is when you get past the categorical judgment and you're trying to figure out a form of words that will allow you to mention what kind of advances are significant enough to be improved upon. The positive test is about as good as anything I've ever seen. And what you really need to do, instead of creating gunky exceptions to these kinds of rules, is to figure out whether there's a better form of words that you could in place which has the same level of generality as the one you have, knowing in effect that you have no interpretive history of the words that you're about to use, and you have a pretty solid one of the ones that you're going to use. And so I think in this particular case, I think Lemley, well, he knows what I think. Just, stirring up all sorts of imaginary difficulties with systems which essentially, if you look at it from the point of view of the litigated patents, may well seem to be a bit dicey. But if you look at the number of, the velocity of voluntary transactions that take place within this system without this kind of stuff is working pretty well. This was a classic case in which people pretended that the engine was overheated when in fact it was humming pretty smoothly.
Anybody in the audience wish to ask any questions of our esteemed panel? Somebody?
Some brave souls. Staring into those lights.
Hi, my name is John Shea. This question is directed particularly to Professor Epstein, but also to the panel generally. I believe Professor Epstein expressed the opinion, if I understood you correctly, Professor, that attempting to distinguish between non-practicing entities and entities that actually engage in commerce under the patent itself is a dangerous legal precedent, and I'm wondering if you can elaborate a bit, given the popularity, at least recently, of the idea of distinguishing between practicing and non-practicing entities.
No, I'm going to put myself on the panel for a minute. As a matter of judicial principle, we do not make decisions based on the character of a party. We don't decide a case because one corporation is big or small, or because someone is from Japan or Korea or the United States. We don't try to identify whether they're a private person or a corporation. We make it based on the law. The idea of making a fundamental distinction of law based on whether someone practices or doesn't practice an invention, the character of the party, is incredibly fallacious. Let me tell you, the problem is not with identifying the character of the party. The problem is with any party who asserts a patent far beyond its worth, value, and contribution to the technical arts. This happens, believe me, I have experience, just as much with corporate and university and other entities as with non-practicing entities. It is something which we have a great responsibility to work on in the enforcement realms of the patent system. And by the way, something I think we've made pretty good progress on.
Judge Aristotle Rader essentially reproduced in the context of patent the one great contribution of the Nicomachean ethics, which is that the merits of a lawsuit and a system of corrective justice do not depend upon the independent status of the parties.
What did I just do? Tell me again.
What you did is essentially if you go back and you read the Nicomachean ethics and
that's what I'm having trouble with.
NICO, the Nicomachean ethics, Aristotle was half fruitcake and half genius. Some of the stuff when you read it, you laugh out loud, but the basic point he made about corrective justice was not to tell you how the principles ought to operate, but to tell you a set of basically conclusions or considerations that ought to be irrelevant to its operation. and he made it into a transactional, what I did to you, what you did to me type situation, rather than whether I'm a serf or a foreigner or a man or a woman and so forth. And just getting the irrelevant stuff off the table is, of course, a great achievement in sort of political philosophy, because if you get all the bad stuff off the table, you have improved odds of getting the stuff that belongs on the table in the right place. But I don't think the question that was being asked of you was a judicial question. That is, if you go out there and you start looking in the reformist literature, what people are trying to do is not to question the way in which you apply the law to these various parties, but to insist that there is, in fact, a deep reason why it is that we as policymakers in reforming the statutes ought to create a distinction between the two kinds of parties. And I could remember, for example, that there were several times when I spoke to many people who were very active in large firms, and I would tell them that I was talking to patent aggregators. They basically accused me of sitting down with Satan and trying to figure out how to carve up the body of some helpless child in order to be able to suck its blood. And then what happens, of course, is many of these people turn out themselves to have patent portfolios of great value, and all of a sudden they realize if they assemble them with other patent portfolios by other peoples, they can increase the market sales. So what they did is, instead of denouncing the practice any further, they entered into the same line of business. My own position is as follows. If you go back to the early days, I think it's the Continental something or other case from about 1908, what they do is they say, in effect, that when you have a patent, you can practice it, you can sell it, and also, and it's a very important rule, is you can also basically deep six a particular patent in one particular area on the grounds that it allows you to take something else in the same constellation to market it uniformly. So there is no particular duty to market any particular patent, and that is perfectly consistent with overall social welfare. So to give you a kind of a concrete case, if you're a company and you happen to be called Searle and you happen to come up with a drug which is called Celebrex, and you decide to push that, you claim that you actually have a patent on a rival drug known as Vioxx, as it turned out to be, which is covered by another one of your patents. I do not believe that you're in a position where you either forfeit the Vioxx patent unless you market it, because you've made the judgment that using concerted effort in this particular way is fine, and if anybody wants to pry the other patent loose from you, what they can do, of course, is to buy it to negotiate its operation. And if you don't do that particular situation, then in effect it creates all sorts of crazy incentives on how it is you're supposed to do your research in the first place. So basically what happens is the way in which the patent system works is you have to be very clear that when you give the functionality claims, and I'm not an expert on this, the guy sitting on my left may well be, not may well, it certainly is you generally have to remember in drugs, as you did with respect to the telegraph, the lesson of the Morse patent. Is you could patent a device that allows you to exploit the electromagnetic spectrum, but you cannot sort of patent a device, make a patent which says anybody who wishes to use the electronic spectrum has to come to me. Now that's what's at stake with respect to the BROC1 and BROC2 genes, and let me see if I could explain why it is I think that this is a really very interesting and complicated case. I mean, on the criteria, even though there may be some dispute about the facts, is that if you go back to the original decisions going with respect to the patenting of adrenaline and so forth, what Learned Hand said in a casual one-sentence opinion was, by the time you isolate and purify this stuff and put it into a test tube, I'm not just going to give you a process patent because that's too weak. I'm going to say commercially it's a new substance, so you got a substance patent. And that's the origin of the isolated and refined and purified language, which essentially is the origin of the entire modern DNA, RNA, recombinant gene technology. What he did not say in that position is that by virtue of isolating and identifying this stuff and putting it in a test tube, it gave you exclusive rights to use that thing when it was a substance of nature which was located in the body. And so the real question you have to ask on the Brock patent cases is whether or not they should get a patent test myriad for the way in which you identify that in the body, at which point others can do that. But my view about it is I don't think you ought to be able to get a substance patent which controls the way in which a particular person uses his particular genes in his own body. And what gets me disturbed about the way in which the case has gone through the courts is instead of basically going back to first principles, understanding how it was that Learned Hand came to his decision, amazingly important but amazingly casual, what happens is This case seems to be in the area of non-patentable subject matter under a very narrow rule, which doesn't have anything whatsoever to do with the way in which one ought to be able to do with the isolated and purified kinds of sides. So I do think that there's a serious problem here, and the prediction that I would have is I think if you can start to, give a patent on radium, for example, when it's in the body, because Madame Curie managed to isolate it and so forth, you will create bottlenecks just the way in the fact if my good friend Contreras would discover the Pythagorean theorem at an appropriate point in time, trying to give him a patent on that so every mathematician that had to use it would necessarily have to pay him a fee. The judgment would be the blockade value overstates it overshadows by a very large margin the incentives for production things, and the essential natural substances, natural formulas, and mathematical stuff is essentially designed to get that. And when you get it wrong, like in the Funk case, we just didn't understand what he was doing about, at that point you start getting difficulty, but that's the line you want to police.
I would also like to address the assumption in the question that non-practicing entities are somehow a new phenomenon, going back to my point about the history. And this goes fundamentally to Richard's point about the essence of the American patent system, which is what distinguished it in its very early years from the English system as well, was that in securing patents as property rights also meant that you had free conveyance and free alienation of these as property rights. As those of you who are law students know, restraints and alienation are absolutely prohibited at common law, and they applied that rule to patents. That was not the rule in England, where patents were deemed to be personal privileges and therefore were deemed to be inalienable unless expressly accepted out by the Crown in the grant itself. Now, what this meant is that the American patent system had built into it from the get-go a commercialization principle, and this was immediately exploited by patent owners who did not, quote, manufacture the invention, but nonetheless practiced it by licensing. So I consider licensing in part an action by which one practices an invention, because you are granting authority to others to manufacture. And in fact, the very first prominent non-practicing entity was Charles Goodyear, who, by the way, had no relationship whatsoever to the tire company that was formed 50 years after he died. But he invents the vulcanized rubber in the late 1830s, gets a patent on it in the early 1840s. He never manufactured patented rubber in his entire life. What he did was license people. And he also engaged in hundreds and hundreds of lawsuits against people who infringed his patent. Manufacturers. Another prominent non-practicing entity was Elias Howe, who I mentioned in my opening remarks. In fact, Elias Howe precipitated the sewing machine war by bringing the very first lawsuits against the sewing machine manufacturers. And this was recognized at the time. He was accused of, quote, suing his way to fame and fortune, unquote.
Well, on that,
And also, if you want to include non-practicing entities as somehow a problem, you would have to identify Thomas Edison as a fundamental problem in our patent system, because Thomas Edison was a non-practicing entity. He ran an invention factory at Menlo Park, and yes, he put his name on a bunch of companies that implemented his inventions, but he wasn't running those companies. He was running Menlo Park, and he licensed his patents to those companies and licensed his name to those companies, and then took the money and put it back into his inventions at Menlo Park. He was basically running an early version of what 3M now runs, and for the sole purpose of coming up with more inventions, which is why he has 1,100 patents to his name. So just be wary about the assumption that somehow there are people today now who are just holding patents and licensing them, and when they go to people and ask for licenses and people say no and then they sue them, that is a new phenomenon, because that actually has been occurring in our patent system and is part of the theory that justifies our patent system from the very get-go.
I think, but also to that, although non-practicing entities may not be a new phenomenon, what is emerged over is the different business models and how those licenses are sought, what the cost of litigation is, and when you're an individual company, what's the cost that you're willing to engage in to either defend that indeed this person who has approached you did not actually invent it, whether it's an overly ambiguous patent that, as Judge Rader said, is this patent that they're seeking to assert against you, is it beyond the bounds? Are they asserting something beyond the bounds that it actually covers? And so looking at that cost-benefit analysis, when you're looking at the overall cost of what you're facing in the litigation system, there's a different analysis that took place maybe at the origination of our country.
Well, those are a lot of interesting empirical claims, which I think, as Judge Rader and Richard has established, and I've confirmed in my own research, are completely empirically unverified. Because no one has established yet the baseline for what makes patents ambiguous or not, and whether patents were more ambiguous or less ambiguous 100 years ago than they were today. And in fact, I just did a blog posting which was titled "Early Pharmaceutical Patents Look a Lot Like Software Patents Today," in which I quote from Judge Hand from the Park Davis decision, where at the end of this decision he has a long paragraph in which he goes on this rant about how I have no idea what this chemistry is, this is confusing stuff, turns out to be a battle of experts, and I'm just an idiot judge and I have no basis to figure this stuff out. And by the way, this means that lawsuits are taking more time and this is more costly and this is a problem. And he raises all the same complaints about early pharmaceutical patents that you see Judge Posner and others raising today about software patents. And yet, he nonetheless came to a decision, held the patent to be infringed, and then people could order through private ordering and make the investment decisions they need to make, because unlike Judge Posner, who took the unsolemn act of actually cutting the baby in half in his decision in Motorola, Judge Hand actually decided the infringement issue before him. So, I can tell you, I've read every patent decision from reported patent decision in the 19th century. There's 1,400 of them in the Federal Cases Reporter, and you get the exact same complaints there as well as that you're making now. These patents are ambiguous. It's hard to figure them out because technology is always on the cutting edge. So yes, we look back at 1830s and we say, oh yeah, that's totally obvious to us. Well, yeah, because we now are far beyond that knowledge. But in the 1830s, for instance, with respect to Morse's patent, no one even knew what electricity was yet or what electromagnetism yet is. And yet he's getting a patent on a device that uses it. Charles Goodyear did not know what the chemical processes were that went into making vulcanized rubber, and yet he got a patent on it. And so the accusations about there's more ambiguous patents now is great rhetoric, but I've yet to see any actual substantial evidence that shows that, yes, patents today are in fact more ambiguous and more problematic than they were 50 years ago or 100 years ago or 150 years ago.
But is that actually the test? I mean, just because there may have been ambiguous patents in the past, that doesn't necessarily mean that we should accept the state of having ambiguous patents in the present, right? I mean, in fact, that
George,
probably...
George, that's not my claim. You're saying that doesn't mean we should accept ambiguous patents now. But you're assuming that ambiguous patents are a problem now. That's a nice assertion and a nice assumption. If you're going to make that claim as an empirical claim, you've got to back it up with the empirics. And right now, beyond a bunch of anecdotes, and by anecdotes I mean here's an unclear patent, here's an unclear patent, here's an unclear patent. Well, I can identify thousands of unclear title deeds which are litigated in state courts every year involving real property. Does that make real property unclear and ambiguous?
It makes those title deeds unclear and ambiguous, and they should be clarified.
Well, the question then is, do you improve things by having two adjudications? One of the basic arguments about res judicata is you're going to be better off with one well-litigated case than a case which is litigated and is then relitigated time and time again. So that the question that has always come in when you start teaching res judicata as a first-year, first procedure student is, do we want a second judgment? And if so, what you have to do is to establish that the improved reliability of the second judgment justifies the additional cost of the first. And if you don't do that, then you're better off sticking with that. And so the correct thing to do under these circumstances is not to pass this huge, crazy kind of statute, but the way in which I would do it is if you find an area where you think there's something which is wrong, give a specific remedy. And I've indicated to you what I think is instructive is the one claim that seems to have a lot of traction about the Brock patents is in fact what I think may well be an unjustified extension of the kind of protection by giving you protections for substances as they appear in the body. And if you get rid of that patent, it means that any woman can have her genetic situation tested by a device which is made either by Myriad or by anybody else, which I think is the right answer. Now, look, I'm not going to speak on the ultimate merits of this particular case because I'm not quite sure exactly all of the claims that Myriad makes, and you won't want to prejudge them. But conceptually, I think it's quite inception that the one illustration that somebody comes up with is an illustration which actually on a conceptual basis challenges very traditional 19th century assumptions about the scope of patentability. And what you really want to do is to get a situation where the ambiguity arises, where the doctrinal issues are not intruding. Got another question?
Good afternoon. My name is Chuck Meyer. I'm from Houston, Texas. And before I ask my questions, I'd like to give you a few of my biases. First, I'm the former general counsel, Research in Motion. In fact, I was the general counsel of record in the NTP litigation.
Oh, okay.
Secondly, I left Research in Motion in 2003 to go to Oxford University to be a graduate student in their law faculty to do research on patent remedies in the UK and also in continental Europe. And with those biases aside, additionally, I'm a former patent examiner who, during the pre-TRIPS era, participated as a junior staffer on the pre-TRIPS negotiations, which leads me to my two questions, one of which the good law professor from George Mason already touched upon, and that is, under the English system, which was in effect, I believe at the time, of the Constitution, it was not a property right, and you defended your grant, your patent grant, on the equitable side of the equitable law divide. So my first question is, does that English practice inform us? And are we moving to a legal system, a law system, the common law side, through this administrative process more than an equitable side? And my second question is, does TRIPS inform us in any way, or does international practice inform us anyway as to how our current patent system melds into the international patent scheme? I didn't hear any of the panelists mention either, would mention anything about international practice. So.
Go ahead.
Well, TRIPS is largely a reflection of U.S. Norms imposed on the international treaties.
Accepted by the international city. Imposed is not the word you want to be using.
Fair
right?
enough, fair
Okay,
enough.
come on, let's keep it straight. And yeah, and not only that, their interpretive step in our non-obvious test of functional equivalent. The single largest area in which there seems to be some difference of opinion is the scope of compulsory licensing under TRIPS and in other countries relative to the United States. And what happens is many people misunderstand the way in which that particular situation is done. If you look under this question, there are two keys. One, the question is, what's the definition of an emergency? And then the second is, what do you do after the emergency has been established? And people in the traditional view say you don't have an emergency if there's a long-term shortage of a drug because you think the price that's being charged by somebody is too high. Or what you think of as an emergency is all of a sudden there's been a terrible earthquake and you have to have huge supplies of a certain chemical coming in order to stop an immediate infection. And there's no question that if you go to the European interpretivist on this stuff, they tend to treat chronic undersupply because of over-high prices as being an emergency which justifies intervention under TRIPS, which I regard as a very dangerous phenomenon. But if you then look at the TRIPS, the other thing is once you decide to declare that emergency, it's not as though you get to use the thing free of charge. What it is it specifies that what you have to do is to establish a remedy on a, quote, commercially reasonable basis with respect to the guys in the home company. And what the folks at TRIPS tried to say, or at least the advocates of weak property rights, is that commercially reasonable is essentially marginal cost. And that seems to me to be 100% wrong with respect to the basic theory of patent rights. As we well know, the marginal cost controversy, which started with bridges, indeed in the Charles River case, that's one of the issues that was implicitly involved, is that you cannot run a system of patent law by charging marginal costs unless you have huge government subsidies for the front-end investment, and God protect us from that particular illustration. So that the price of running a patent system to get the innovation is to exclude at the margin for a certain period of time people who are willing to pay above marginal costs but below market kinds of prices. As far as I can see, all that the TRIPS agreement did, if you read it correctly, was to allow you to force the exchange but did not allow you to impose marginal cost pricing as a function of the exchange that you enforced, and that the commercially reasonable rates would necessarily require that some portion of the fixed cost of patent invention has to be charged to you because they cannot be put on everybody else. Now, doing this turns out to be extremely difficult for the following reason. There have been a number of people, Patricia Danzin for one. If you start looking at these countries and see the prices that they charge, basically what happens is you charge them in a kind of a price discrimination way so that in the U.S. with the highest and most robust demand, you get the highest prices, and other places where the demand, because the economies are not as large, you get somewhat lower, and the correct TRIPS formula should be replicate what would be the voluntary price of something close to it in the country at hand. And the reason this is so important is if you do that, it essentially forces you to the real emergency type situation because there should be little or no gain that you can get by forcing compulsory licensing if, in fact, you have to do something which is quote-unquote commercially reasonable. And virtually every defendant of the TRIPS walk-in right situation ignores the second part of the provision having to do with commercially reasonable rate and simply talks about the first one. And you know, look, I mean, you work for a company which essentially, when it settled its great case, right, got on the low end of the distribution. And I don't know if you followed it, but I certainly have. It seems to me that research in motion is kind of stuck in the water at this particular point in virtue of the fact that the next generation of technologies have gone over. And one of the lessons I think people should learn from this is that, you know, what is today's dominant technologies turns out to be tomorrow's has-beens. And if you recall, in 2000, there was this Time Warner AOL merger, right? In which the dominant player was AOL and the weak player was Time Merger. And everybody got up there saying, oh, with this patent brigade, this world is going to come to an end. And it did. AOL faltered. Time Warner spun it off. The AOL is a marginal player, not a dead player, but certainly not a dominant player in its respective nut. And it turns out that Time Warner suffered a real blow because it actually had to pay some money over in order to procure the separation, which would allow it to operate as a coherent business. And one of the mistakes that you get in this literature all the time is people somehow or other think that these conglomerate mergers work. And for the most part, they don't, because the difference in cultures makes it better for you to get together by spot contract rather than by permanent governance structure. And one of the reasons why the patent law is so messed up today is most of the people who critique it know absolutely nothing about industrial organization. So they draw these kinds of fantasies about how the system puts together. This is a real kind of a mess. And I will be quiet because the gods have silenced me.
If I could have one brief follow-up, and that is, the system as it currently is constructed, can it compete with other regimes for enforcing patents throughout the world? We're seeing a lot of litigation in other countries. The German patent system is viewed as one of the best places to litigate a patent in continental Europe. Have we created a system which will put us at a disadvantage in terms of patent litigation throughout the world, or have we created a system that will give us advantages?
Well, look,
compared to
this
the
is
rest of the world?
just simply a replication of Sarbanes-Oxley. What that did is it managed with great heroic things to protect the American market so as to make sure that 90% of the IPOs would take place either in Asia or in Europe. And the AIA is going to have exactly the same consequence. This is the deindustrialization of the United States is obviously a major goal of current policymakers. And it seems to me that they are sadly misguided.
Thank you.
Next question.
This will be the last one.
Yes, my name is Stephen Wallach. I wonder if Ryan or Richard would comment. My notion of the AIA was that it was supposed to encourage combatants to go into the patent office instead of into litigation, and thus maybe there wouldn't be the res judicata problems that Richard is concerned about.
You need to read the act.
Yeah, that was definitely the purpose. The initial reason why we even looked at either making revisions to the IPR process. I think that throughout, as was mentioned, throughout the compromising and negotiating process, many of the things that we were looking at the time that would encourage going over to the PTO ended up being pulled out. Because there were concerns that potentially some of the ones that are being expressed today, that it would be a system that would be used for abuse, that you would have duplicative processes that would go on both in the courts and over at the PTO. And so I think that what ended up happening is that, at least in the perspective that too many restrictions were put on the new processes over at the PTO to provide an effective alternative to the district courts and at least refining around the edges of what a patent should encompass.
You know, look, I think there's a certain dreamlike quality to that answer. There are two times that the patent office could get involved. One is before litigation and one is after it. And if you want to improve the average quality of the PTO, you don't need to have ex post adjudication going back to the PTO. You should just strip that from the statute and concentrate on its internal operation. And my real fear about this system actually is that as I think the act itself became politicized, my fear now is that examiners and these sort of half judges that come into these things, there will be a real selection judge in the way they do it. My view is Having federal district court judges have the shot at the first thing means that you can't rig the system, and then having random panels at the federal circuit essentially is an additional protection. But when you allow people to appoint judges to adjudicate cases on an individual case-by-case basis, that's like roughly saying, you know, I've got this big case involving Microsoft. Well, I think I'm going to get some guy from Google to be the judge in order to handle it. The power to select is the power to destroy within the system, which is why it is you guys tend to get random panel assignments, don't you?
Yes.
It's a good protection. You don't get any randomization inside this system. I mean, the process values that were respected here are just terrible in terms of their implications. And the things that are done in the name of improving efficiency really go far beyond what that requires.
Also,
I think that's our last question. Thank you very much.
And